team. Today we will consider an audit into certain actions and processes of the Administrative Office of the Courts. We will start by taking the testimony from Kentucky's Auditor of Public Accounts, Mike Harmon. Mr. Harmon is here to present his office's findings of a review of the AOC to ensure that it is prepared to properly safeguard taxpayer funds and public property. Thereafter, we will hear from the Chief Justice of the Commonwealth of Kentucky, John Minton. As the head of our judicial branch, Chief Justice Minton oversees the AOC, which assists him in administering and serving a major portion of the Court of Justice. Put another way, the AOC is the office of the Chief Justice. It is also the Chief Justice's duty, in conjunction with the Associate Justices of the Kentucky Supreme Court, to manage and oversee the activities of the other agencies of the Court of Justice, including the Character and Fitness Committee, the Board of Bar Examiners, the Judicial Conduct Commission, the Judicial Ethics Committee, and the Kentucky Bar Association. Chief Justice Minton is here today to provide his office's response to the auditor's findings and recommendations related only to the AOC. Anytime Kentucky's auditor presents to this body, it is an important affair. And when the Chief Justice of the Commonwealth appears before the legislature, whether it is to advocate for the Court of Justice budget, to persuade the legislature to improve the law on a particular matter, or as he is here today, to respond to findings about his office, it is, in my opinion, a matter of considerable importance. As we begin today's hearing, I want to expressly recognize a tension that is also recognized by the Chief Justice in his office's response to the audit, and to acknowledge our respect for the differing prerogatives and powers of the offices represented here today. The Kentucky Constitution bestows upon the legislature the sole power of the purse, and in carrying out our duties to appropriate public funds, we must monitor expenditures of those appropriations, which includes the handling of taxpayer property and contracts to expend public funds. So we, the legislature, must carry out our fiduciary duty to the people that we serve. Perhaps in tension with performance of this duty is our respect for the role of the judiciary and the separations of powers, which in Kentucky occupies a special place in our history. It has been said that Thomas Jefferson himself drafted Kentucky's two separations of powers provisions, which are sections 27 and 28 of our fourth and current Constitution. They were originally sections 1 and 2 of our previous three constitutions. These sections are of such importance today that I wish to recite them here. Section 27 reads, "The powers of the government of the Commonwealth of Kentucky shall be divided into three distinct departments, and each of them be confined to a separate body of magistracy, to wit, those which are legislative to one, those which are executive to another, and those which are judicial to another." Section 28 reads, "No person or collection of persons being of one of those departments shall exercise any power properly belonging to either of the others, except in the instances hereinafter expressly directed or permitted. In compliance with those constitutional prescriptions and proscriptions, our Constitution assigns various powers to particular branches of government. Here, we have the textually committed power over appropriations belonging to the legislature, in tension with the authority of the Chief Justice to administer the Court of Justice. Sometimes, although thankfully rarely, those powers come into conflict. Perhaps they do here today. So we are very thankful that the Auditor and the Chief Justice are here to discuss with us not only the findings and recommendations of this particular audit, as concerning as they are, but more globally, and perhaps much more importantly, to consider what we, the legislature, might do to protect against future breaches of the public trust, and to better understand the proper bounds and roles of the legislature, the executive, as embodied by the auditor at present, and the judiciary. We'll start by hearing the findings and recommendations. So without further ado, I give the floor to Kentucky's Auditor of Public Accounts, Mr. Harmon.
Thank you, Mr. Chairman. Before we get kicked off, of course, I know we normally introduce ourselves. I'm Mike Harmon. I'm Kentucky's Auditor of Public Accounts. I'll let my staff introduce themselves.
Chris Hunt, General Counsel for Auditor of Public Accounts.
Tiffany Welch, Performance and Examinations Manager.
Thank you. Mr. Chairman, members, thank you so very much for having us here today to testify about this important and what we believe to be a historic examination. Now, our exam began last year at the request of the AOC Director and Chief Justice Minton, and was released July 12th of 2018, so just a little way to go. Now, this is the first time that the auditor's office has taken a comprehensive look at AOC, but we believe it shouldn't be the last. Now, this was a special examination of the policies and operations at AOC, which is a little bit different than a financial statement audit. Our examination looked at AOC's operations between July 1st, 2015 and June 30th, 2017, unless otherwise indicated. Changes to the Kentucky Constitution in 1976 created the modern court system that we use today. Now, since 1976, a Chief Justice has served as the executive head of the court system. AOC is used to carry out that function. Now, our report contains 20 findings and identifies a wide range of areas that need corrective action. The report is available at auditor.ky.gov. It is organized into 5 areas: control environment, inventory, employee transactions, facilities, and IT security for the state's case management system, which currently is Kentucky Courts 2. Overall, what we found from our examination of AOC was disorganized and unchecked leadership in the judicial branch operations in a number of areas. AOC failed to follow many of its own policies and often simply didn't have sufficient policies in place to provide transparency and oversight. Now, this resulted in a weak internal control structure and an overall lack of accountability at AOC. For example, documentation is not consistently required or maintained for things such as exceptions to competitive bidding, private sector leases, credit card transactions, and employee personal mileage. A significant problem with the structure at AOC was seen in the treatment of officials. Some examples include a lack of approvals for reimbursement requests and higher meal reimbursement rates for the Supreme Court justices compared to other employees. Now, AOC does not follow its vehicle use policy requiring monthly reporting of personal mileage. Justice Wright failed to report personal mileage for nearly a 2-year period for his official take-home vehicle until our auditors began asking questions. However, 4 months was still unaccounted for. AOC did not properly report these taxable benefits for the justices and other personnel. This issue, this was one of the issues we referred. We've actually referred this to both the IRS and the Kentucky Department of Revenue. Now, to address this structure and this culture of accountability problems, we made a simple, just really a simple recommendation: require everyone, including officials, to follow the same rules or face consequences. AOC responded that it has no role in holding elected officials accountable. This, of course, is unacceptable to myself. No one, including judges, should be above the law. Now, the media reported issues with employee-only sales of the surplus property even before we began our examination. We found that AOC did not follow advice from its own legal counsel in 2010 regarding these sales. The executive officer who coordinated the sales also participated as a buyer. Now, what we found was several issues with the reported mileage of the vehicles sold. Of the 15 vehicles sold during these employee-only surplus sales, the mileage on 10 of those vehicles was incorrect in the advertisements for the sale. Now, some were advertised higher, some were advertised lower, but the 2 largest discrepancies we found were the vehicles purchased by the former executive officer. Now, the former executive officer purchased multiple items at employee-only sales that he conducted, including the 2 vehicles we just discussed that were advertised as having 47,000 and 79,000 more miles than what records show they actually had. This finding was referred to the Attorney General. Now, in addition to sales events publicized to employees, from 2012 to 2017, AOC also sold property to officials in private transactions, including 2 Supreme Court justices. Former Justice Scott purchased a vehicle, and former Justice Noble purchased furniture in private transactions. Prior to April 2017, there were not effective policies or oversight in place to prohibit these activities. Now, in the absence of effective oversight from either within AOC or in an external source, some conscientious employees may become careless, and some employees may be tempted to take advantage of the situation of this personal benefit. These findings support our broader finding that AOC's policy-making process is broken. AOC policies are scattered, conflicted, and ambiguous. The Chief Justice shares administrative policy-making decisions with other members of the Supreme Court. And of course, this led to a slow process with personnel policies taking 2 years to finalize. Now, of course, discovery of these meetings on administrative matters led to another recommendation that AOC disagreed with in their response. We recommended that they have open meetings for these administrative decisions by the court. It was reported to auditors that Chief Justice was outvoted when a policy change was denied to decrease lodging reimbursements for justices. AOC disagreed with this report. However, if these meetings were open, votes on this nature could easily have been verified. Now, if the court continues to make decisions in this regard, when we're talking about administrative matters, they should do so with the same level of transparency that applies to other governmental agencies. AOC's ethics rules are not well developed and lack sufficient enforcement. Now, APA recommended creating an independent commission like the Executive Branch Ethics Commission. AOC obviously disagreed in their response with this recommendation, stating that it has no authority to organize an independent body to govern employee conduct, which we found that a bit interesting because in 2013, the Supreme Court created the Circuit Court Clerk Conduct Commission, and AOC should go back and they should reconsider whether a similar commission can be created for their employees. Now, we found that conflicts of interest are not specifically prohibited by AOC policy. Employees are to report conflicts of interest, and that is what we could tell the end of the policy's guidance. For example, there is no written policy at AOC to prohibit leasing property from related parties. Now, related parties are required to disclose in some instances, but no policy on whether this conflict is acceptable. For example, AOC leases office space for Justice Wright from a company owned by his sons. AOC records do not explain why this space was chosen, despite the fact that it cost 3 times more than the alternative proposal. And this was not the only example of questionable conduct and lack of policies at AOC. Most of the credit card purchases made by Chief Justice Minton and AOC Director lacked any supporting documentation. Adequate controls, such as cardholder agreements and documentation, were not used for credit cards and pro cards. In one instance, the AOC Director instructed a staff member to purchase personalized mint julep cups for outside parties at the request of the Chief Justice's spouse. AOC makes payments to local governments for court facilities it leases. And during that time, the internal audit process was in place for these payments, but we discovered there is no follow-up to confirm payments are made consistent with those audits. This resulted in over $300,000 in errors in local facility payments over a 2-year period. Confirmation should have been performed, especially since the AOC reported that the audits were modified by the former executive officer. Now, in addition to surplus property issues, there are significant inventory problems at AOC. Auditors identified $2 million in inventory errors. AOC is at high risk for assets going missing. For example, 2 new laptops were reported missing at AOC because of poor inventory controls and failure to follow policies. And interesting enough, when we interviewed the person that basically signed off on receiving those particular laptops, he admitted to our staff that he had not actually counted the laptops when they came in. So it's hard to tell whether or not someone took them or if they just weren't part of the actual shipment. Now, AOC maintains 3 separate databases for inventory. The third database was created because one department did not trust the data entry of another department. And of course, rather than correcting that, they just created their own, a third database. Now, our report includes an entire section on IT security issues for Kentucky courts too, including giving unnecessary access to some current employees and not revoking access to some former employees. And one of those actually had access over a year after departing. Now, this indicates that AOC operations require improvement across the board and in all areas, which is why we recommended greater oversight in this particular area. Now, the first step towards oversight is this examination, which identifies key problems with AOC's operating environment. Now, throughout the report, we make multiple recommendations along with each finding to begin the process of corrective action. AOC provided an initial response, and an additional response will be due 60 days after the release of our report. Now, AOC's initial response indicated disagreement with key recommendations. We felt like key recommendations, especially regarding transparency and accountability, including holding officials accountable to administrative policies and a statutory requirement for annual financial statement audits. Now, I'm recommending, and that's why I'm glad that we're before this particular body, I am recommending that the General Assembly require an annual external audit of AOC, with the Auditor of Public Accounts having first right of refusal for that audit. Now, the results of this examination show that external oversight is needed. AOC disagreed with this recommendation, stating that the Supreme Court should decide whether to have and how often to have audits due to the separations of powers that we talked about a little bit earlier. However, according to a unanimous Supreme Court opinion in 1980, the legislative body may require audits of funds appropriated to the judicial branch. Therefore, the Supreme Court's own prior decision supports our recommendation that the legislature may require an annual financial statement audit of AOC. Now, no matter whether it's the judicial, legislative, or executive branch, we as leaders in the Commonwealth owe it to the taxpayers of Kentucky to strive towards openness and transparency. The recommendations in our report, if fully supported and implemented, would change the culture of AOC and provide taxpayers with the transparency and accountability they deserve from the judicial branch of government. Now, AOC management, Chief Justice Minton, and the other members of the Supreme Court should take action to address all the issues that we've identified this. Now, as part of this, even before we began this particular examination, we had agreed to come into AOC and actually do some training, and staff actually did some of that training earlier this week, and certainly we are hopeful that that training was received well, and we hope that they will take that training as well as our full recommendations and move forward with that. Now, I will say, from a standpoint, we cannot tell AOC how to do things, but we really believe that our guidance is very important to the future of their transparency. Again, thank you for allowing me to come and speak before this committee, and certainly at this time I would be open to any questions.
Before we do that, I think we're going to take roll, and then we're going to have Senator Schickel lead us off in questions.
Senator Jones, Senator Schickel, Senator Webb, Senator Westerfield, Representative Elliott, Representative Lee, Representative Petrie, Representative Reed, Representative Simpson, Representative Sinnett, Senator Humphreys, Senator McDaniel, Representative Fisher, Representative Rudy, Co-Chair Schroeder, and Chairman Nemes.
Here. I know a lot of folks are in the tax modernization committee. A number have already come in, and they'll be in and out, I suppose. Senator Schickel?
Thank you, Mr. Chairman. I believe, and thank you, Auditor and staff, for being here. It's good to see you. I believe I'm the only non-attorney sits on this panel, so sometimes I need some extra tutoring. And I'm curious, and I think I know the answer, but I just want to make sure I'm clear. When you're talking about previous Supreme Court rulings about the separation of power issue, you're talking strictly Kentucky Supreme Court?
Yes.
Okay,
Yes, that is correct, yes.
thank you.
I want to ask a question real quick, or
Sure.
before we move on to more questions and do some things in particular, or a series of questions. I wanted to point out, you did point out, but I wanted to highlight that this audit was at the request or the invitation of the Chief Justice.
Correct.
And I think that needs to be highlighted. It was his effort to open and to find the things that are wrong so he can fix them. I think that is a major point to be made here. And I also want to note the mint julep cups. They cost $410. It seems to me that there's nothing wrong with that. In fact, it seems to me that that is desirable, that when an outside group comes to Kentucky, that we advertise ourselves. And I mean, if it were $4,000, maybe we have a different argument. But a trinket like a $410, and I think it was a number of people. I think you said at Mrs. Minton's request. And then Laurie Dudgeon, the director, had. I don't see what's wrong with that. In fact, I think that's
May I
that's a
comment,
good.
Mr.
That's my question. I think it's a good thing. So what's wrong with it?
Well, I think it's very important because, one, it's not an appropriate use of taxpayers' dollars. I understand what you're speaking of, but, we do over 600 audits a year, many of them, most of them dealing with counties. And I've seen finding after finding, basically, elected officials using taxpayers' dollars for smaller amount than that we basically have to have a finding in that regards. I can let staff explain it a little bit further,
Okay.
But basically there was, if I remember correctly, a previous Supreme Court ruling that they can go into that we have to hold them accountable to that degree. So if we're going to hold them accountable, then we got to hold the judiciary
Oh,
accountable.
I'm off for that. I do have just
Yeah.
a couple particular questions. There's no allegation of self-interest or
Sure.
individual benefit here on that question, right? Okay. And I would request if there's any policy, state policy or court policy that would disallow that kind of expenditure, if you could give that to the legislature.
Sure.
It seems to me that shouldn't be something that's illegal, and we ought to be promoting ourselves to these types of folks from out of state who are doing a service to Kentucky anyway.
Sure.
But there's a lot of other things I have questions about, but right now I'm going to give the floor to Representative Reed.
Thank you, Auditor. One question I had, this was a procedural audit. This was not a financial audit, correct?
Correct. This was a special examination.
Okay, do you think a financial audit should be called for?
I think a financial audit should be done every year going forward. And that's one of the reasons why we are thankful before this body, is because we would like to request that. But this particular, and as the chairman indicated, we were thankful that Justice Minton and AOC Director asked us in. But, given that there'd been 40 years plus with no external audit, in this particular case, special examination, it just basically showed the importance of having a financial statement audit every year.
While others are thinking of what questions they might have, I've got some particulars.
Sure.
There are some major areas, I think, that you've outlined, a number of them that give me great concern. I want to start with the thing that gives me the most concern, and that's the lease with Justice Wright. Do you know who made the decision to lease with Justice Wright? I think the LLC that has two members, and both of those are only his sons.
I'll let staff talk a little bit about that.
The decision, there's a discussion of a decision memo that is submitted internally according to AOC policy, and the decision memo is submitted per policy to the director,
Correct, the former EO.
the former executive officer, which would have been Mr. Brown at the time. So under the policy, that's who would have made the decision. The lease documents, this is kind of a convoluted lease situation. There are several modifications that were submitted in the file, amendments. Some of those are signed by various individuals within AOC. So it looked like there were several hands involved during the process, but as far as the policy, the selection was to be made by the executive officer at the time.
When you talk about other people signing it, are we talking about Director Dudgeon or Chief Justice Minton, or are we only talking about Scott Brown and people equal to him?
The individuals that I recall being involved, and there may be others, going from memory of looking at the documents, there is indication that, based on emails, that the director was involved, Ms. Dudgeon, the budget director, and the facilities manager at the time.
And do you know if anybody else knew about it? You referenced emails. So you've talked about the budget director, the facilities director, and Mr. Brown, anyone, and Mrs. Dudgeon. Anyone else? Was there any indication that legal had made it, that the general counsel had made any recommendation?
I don't recall seeing.
I don't recall that.
There's also indication based on emails that Justice Wright had input into that process.
Do you know what timing? It was signed in April of 2016.
In November of 2015, there's an email indicating that the AOC director and the budget director were discussing with Justice Wright alternatives for his office space.
Okay, you referenced emails. What documents have you looked at in relation to this lease?
We have looked at everything that we were able to obtain from the lease file, which I said includes some modifications and amendments. We have looked at some internal emails, what were provided to us through the lease file, the recommendation memo.
Recommendation memo, there was
Anything else?
photographs. I believe that pretty much covers it. Anything that would have been in that file.
Okay, and then the last question is on this issue is: have you looked at I understand that there was a second bid. This one was 2.5 to 3 times bigger, or I guess more expensive. And then there was renovations made, and the lease, I think, is actually annually more than the property appraised for. Any comment on that? And did you look at the second request bid to see if it were something that might have worked or not?
So I think the process internally for this was when AOC wants to procure private office space, they start with county facilities, with public facilities, and the alternative was one of those county facilities. It was next to or in the same building as a health center,
Yes,
health
or
department.
something.
So I don't know that there was actually a formal submission in response to an advertisement, but it was identified during that initial process. Because of that, and just based on what documentation was available in the bid file, which would point out there was not good documentation on comparing the two office spaces in the file, then we don't have a lot of information about that other space other than the cost that was submitted.
Is that something that should be looked into?
It's been looked into from our perspective as far as it impacts the operations of AOC. There are always more details that can be gone into on issues like that.
Okay, I'm going to call on Senator Webb, but my last question is, we've just built a $30 million courthouse in Pikeville. I've been all around that area. It's not very far. Is there any reason they didn't put Justice Wright in the Pike Judicial Center?
I'm not aware of any deliberations at AOC. I haven't seen anything in that regard.
Thank you. Senator Webb.
Thank you. You know, the separation of powers is pretty stout, and as the chairman knows, back in the day, I had a little run-in with the AOC and Supreme Court as well, but the law's pretty stout in what they can do and what authority they have. and I respect that, and I respect the court as it is. And I agree with the chairman. I think the executive branch and legislative branch take some liberty with the budget to promote the Commonwealth and should do so. I don't have a problem. I think that's petty with the julep glasses, but separate and apart from that. The lease situation, I'm more interested in, I would, if I was Justice, I'd want to be in my hometown too. If you travel those mountain roads, I think there's a legitimate reason that Justice Wright is at home, but especially some months more than others. I don't have a problem with that. What I'd be interested in is the alternative site, the other site, the condition of that property, the market comp, if you will, whether it would reflect the face of justice. I think when we have built the courthouses through the years, we want the face of justice adequately reflected. And I think that's important, and not only as a practitioner, but as a citizen, for respect for the court, for the office, and which some people don't seem to have anymore, but it certainly is important to the underpinnings of our democracy, in my opinion. So I'm more interested in the condition of the spot that we're talking about, that separate and apart from any alleged conflict of interest.
Would you like me to respond?
Yes, in a minute. And the market comp for square footage, rental property price, and that kind of thing with the leasehold as it is now.
Chairman, is it all right to respond? Yes, thank you, Senator. And I agree. And I think that's, as we discussed earlier, that's something that if you're going to have a piece of property that is 3 times higher than any other alternative, those are items that should have been properly documented. Had they been properly documented with the proper excuses, we may not actually, or reasons, not necessarily excuses, but if it had been properly documented, we may not be having this finding, we may not be having this discussion. So one of the things that we indicated was there was, a lack of documentation. And that's very important, especially with that larger discrepancy. And going back to the small one, I understand, even when I look at it in regards to the mint julep cups and the 410, but we have to hold everybody accountable to the same standard that we hold our other officials to throughout the state. To do so would be an injustice to them.
If I may, Mr. Chairman. And we appreciate your work and your office and the good work they do. And there's no question, and I think Justice Minton has acknowledged that, there needed to be some administrative controls and oversight and maybe new policies that were somewhat antiquated, outdated, or non-existent. I think we all appreciate that. And I think, I'm sitting here looking through this too, thinking that perhaps that these issues at this time, maybe with the exception of 1 or 2, may be moot. So what's your thoughts on that?
Well, Senator, just getting back just a little bit to the previous one as well, from a standpoint, I've often said that being a good auditor may be like being a good judge. You may not always like what you have to report, but at the same time, you have to be consistent and fair throughout, and that's what we have tried to do.
Thank you. Thank you, Mr. Chairman.
Representative Elliott.
Thank you, Mr. Chairman. I want to welcome my friend Mike Harmon,
Good to see
who's
you,
my
Mr.
predecessor. He held this seat prior to me, and I want to thank him for his work, and he also is my constituent. So it's always good to see him. Mr. Auditor, I just looking over your report, I'm troubled by seems like a generalized hostility to the recommendations that you have made, and to me, just looking at these, they seem very common sense to me, and I would credit the Chief Justice for bringing in your audit of this of the AOC. After 40 years, I think it was overdue, obviously, but 4 of these recommendations that you have made seem to be very, very reasonable to me, and I'd be interested to know why there has been opposition to it, because as long as I'm in the House of Representatives, I'm always going to err on the side of spending public's money in a reasonable and in a way that is consistent. And I think your argument that you have made to the panel about holding everybody to the same standard is exactly correct, and I appreciate that. So I'd just like some comments on really the basis of some of these objections to your recommendations, because they seem to be very reasonable to me at this point, and I'll look forward to hearing from the Chief Justice and the Director. But
I think, from a standpoint, certainly I can't, speak for them. The only thing that I can tell from them is their response. And I will tell you, myself and staff was, very surprised at the response. We knew there was, items that need to be addressed and corrected, and they have begun correcting some of them. But some of the key ones, especially dealing with transparency and accountability, we were a little disheartened at how much they pushed back, or in some areas were dismissive in that regards.
Representative Simpson.
Thank you, Mr. Chair. I appreciate the report. Once again, let me make a comment. My former colleague and seatmate, it's always good seeing you. We appreciate your good work, and we appreciate the diligence that you, in the manner that you conducted the audit. And we think it's a good thing. I think transparency is a very, very positive thing. But having said that, I'm concerned also. I mean, we have a sister branch of government, not an agency, but a separate and distinct branch of government. Now, we're very, very helpful that the AOC through Justice Minton requested your examination, and I think it's certainly going to bear fruit. In fact, having read the very, very lengthy report in fine detail, I was very pleased that so many of the recommendations that I thought should be addressed are being addressed by the AOC. In many instances, inasmuch as it is a separate branch of government, we cannot, or perhaps ought not, expect that they will act in a short window, because they are governed by their own unique rules. And I guess I take the opposite tack from my colleague relative to their resistance to respond to your report. But let me get to the gist of my question. I've read your reply to their reply, and I guess what I want to know, we can't undo the past. And I think due to the efforts of your office that was predicated upon the request, it brought to light some glaring deficiencies. Deficiencies that I know that will be addressed. I think the AOC and Justice Minton, they want to address those. But having said that, of the ones that are not being acted upon in a manner that is consistent with your recommendations, what are the most important ones?
Sure, and thank you. And yes, as my former seatmate, we enjoyed many a day on the floor, which I miss to a certain degree. But thankfully, I have great staff at the office, and very much enjoy the work that we're doing at the auditor's office. Obviously, some of the key ones, certainly from the standpoint of financial statement audit, an annual financial statement audit, I think that's probably one of the key pivotal aspects. Just like hopefully you and I each year go to our doctor annually and have a annual exam to determine if there's anything that needs to be corrected at that time. I think any organization of government that's expending taxpayer dollars should have that same scrutiny on a yearly basis. That is probably the number one. Now, certainly, I think if they are going to share power, and the Chief Justice can address this a little more, but if they're going to share power on administrative matters, I think we should hold them accountable to the same rules that we hold the other branches of government. Now, if the Chief Justice is going to make the decision on his own, then that would be different. But we believe that's an important recommendation as well. Those are probably the two more. Obviously, there's others, but those were the two that we felt like there was the most pushback on, and the two that we felt like needed to be addressed more thoroughly.
Inasmuch as you did broach the other branch of government, which is the legislative branch. Are we under such constraints also, LRC? I mean, are we forced to have an audit from an external auditor relative to the performance that you see of the judicial branch?
Forced, I wouldn't say at the time there's not a requirement, although we believe in the auditor's office, we believe that any time an element of government is expending taxpayer dollars, we believe that we could audit them. Now, in this particular case, we were thankful that AOC invited us in, and certainly you would not be the first person they asked the question as to whether or not LRC could or should be audited, and that's certainly something that we are reflecting on at this time, because we assumed that that particular question would be asked, given that we had audited AOC.
Another thing that was kind of interesting, once again, the separation of power aspect. One of the things that we, at least I think collectively, we strive to accomplish is to have independence amongst the branches of government. I think it's very, very important that the executive branch has no impediments through the legislative branch or the judicial branch, and likewise for the judicial branch. One of the aspects of your recommendations that I was uncomfortable with was the fact that you are requesting a right of first refusal on the audit. Let me tell you the problem with that. Not that your staff is not competent. I think you've demonstrated that since your election, that you're very, very conscientious and your staff is very, very competent as yourself. But once again, when we deal with the core of government and the separation of powers, do you recognize that having an executive agency overseeing an aspect of a sister branch's operation could create a chilling effect that could a possibility of altering the independence and the pure administration of justice?
Well, I think, Representative, if you look at the Constitution as a whole, yes, you have separate branches, but you also have separate checks on each of those branches. The executive branch has some checks on the legislative branch. The legislative branch, because they appropriate funds, have some checks on both the judicial and the executive branch. So there are already those particular checks. Now, as for the auditor having first right of refusal, that is consistent with what we do with the counties. That is consistent with what we did in legislation regarding the ads. Certainly, but we are just merely a flashlight. We do not have enforcement power. We are a reporting agency. So if we find items that need to be corrected, we can make recommendations. We can make, in this particular case, we made referrals to the Attorney General's office and to the IRS and to the Treasury. But from that particular standpoint, it is up to them to pursue it further. We have the bully pulpit, but we do not have enforcement power.
May I? Let me say this. It's once again you conducted the audit. You've done it for a year. I mean, AOC is responding very rapidly, quite candidly, to the voluminous report. And I don't know if the time sequence was really adequate to really glean their true intent on correcting some of the deficiencies, and they are deficiencies that has cropped up throughout the administration of the court system. Whatnot. Do you anticipate doing a post-mortem after the AOC is in the process of implementing policies, some of which would necessitate the adoption of rules by the court, which will not happen very quickly? I would not want to see them this rush to judgment and promulgate responses. Is your office going to do a post-mortem at some other, at a later date? And secondly, when we talk in terms of checks and balances, the ultimate check and balance in government is really the General Assembly, because we're appropriate. And obviously, you know that we're very, very sensitive to the concerns of the executive branch and your concerns. Therefore, do you think that's an adequate mechanism to ensure the protection the public and to ensure transparency.
Are you talking about the audit, or are you talking about the General Assembly?
The General Assembly ability to control the purse strings.
Yeah, I think it's certainly one of the checks, one of the main checks that is presented to the General Assembly, and probably the most important one, and is why we would refer that to the General Assembly to do recommend or actually require a financial statement audit. And it wouldn't necessarily, we believe we should have first right of refusal, but that doesn't necessarily mean that we're going to do it every year ourselves as well. And as for the postmortem, they have a 60-day response required. Typically, whenever we do an audit, we, as you see, allow the people that we are auditing, or in this particular case, a special exam, to have a time frame to respond to the audit, and we've always set that generally at about 3 days. But in doing that, we also provide for an additional response of additional corrective action 60 days out. Beyond that, that's why we are making the recommendations to the General Assembly to have a yearly financial statement audit, so that they can, and a financial statement audit is a little different than what we did, but certainly a financial statement audit will go in detail enough to make sure that they're operating efficiently, effectively, and ethically.
One last question. In light of your request to the General Assembly, and God bless the fact that I will not be here, do you anticipate making a similar recommendation as it relates to the Legislative Research Commission?
Are you talking about whether we're going to audit LRC?
Yes.
Yes, we are taking that under advisement currently.
Thank you.
Yes.
Thank you, Representative. I want to go on the record saying I support auditing at LRC, and I think it ought to be done. So I hope that is your recommendation. And that is what I think Chief Justice Palmore said in Ex Parte Auditor,
Yes.
when there was an attempt to audit the Kentucky Bar Association, which does not receive taxpayer funds. And he said, take a hike. But he did say, nevertheless, to the extent that it has appropriated funds from the general revenues of the state to the judicial branch of government, the legislative body has a legitimate and necessary right to know how those funds have been spent. In short, the legislative body may require that the accounts financed be audited. That should apply equally well to the LRC as it does to the AOC. When we're talking about the difference between a special examination,
Correct.
and a finance audit, I noted on pages 81 and 82 of the audit, you have noted that over $5.5 million have been appropriated for use for circuit clerks that weren't used. They've been given $5.5 million more than they used, budgeted, and they actually spent. And facilities, it's much more than that. So would a financial statements audit, go into what that money was actually used for?
I'll let,
Because as
Chris,
the chair of this committee, when we come up with a budget,
Yeah.
when the Justice Cabinet says they need X amount of money for a particular function, I suppose that's where it's going.
yeah, typically when they're doing a financial statement audit, they're looking at basically the financial statement and comparing it. But I'll let them go a little bit more detail if they.
A financial statement audit is going to render an opinion about the financial statements that AOC has prepared, its management, and say whether those can be relied upon by outside parties. So that's a formal opinion in that context. It will report things like identified in that budget summary you just referenced, as to whether it will determine how money was spent. It will look at how money was spent and whether it was done in compliance with laws, rules, and regulations. But I'm not sure really what your question is about what it will uncover beyond that.
Okay, thank you. Representative Fisher, Chairman Fisher.
Thank you, Mr. Chairman. I'll send my regards to my seatmate as well. He was between Representative Simpson and myself for many years. First question, I did recall reading in the report something about internal auditors that are part of the AOC. What is their function?
I'll let them go in more detail. It wasn't necessarily what we would normally think of as an internal audit.
They provide audit services. They're not truly an internal audit function in terms of official IIA standards, internal auditor standards. They perform audits of master commissioner funds. They also do some circuit court clerk funds. that type of thing. And periodically, during our examination period, we looked back about 5 years. The last, I think in there somewhere, that shows their last 5 years, how many internal audits they've done or any requests for management. Those were very limited. So they don't really look at AOC's internal operations as much as they are present in the counties.
And do they audit the circuit courts?
Circuit court clerks.
Circuit court clerks.
Right.
Okay.
there's been-
Let me ask you about credit card usage here. How do they distribute credit cards? I mean, is it in the name of the AOC? I can tell you in private practice, most of these cards are in the individual employees' names, and you have to provide documentation to justify a particular purchase that is made. Is that what happens here?
Based on my memory, what I can recall, there were 3 credit cards. They were specific to individuals with a certain limit on them, but I cannot recall if it was I believe it's on AOC's. It's AOC card with their name on it. If that makes sense, it's still the responsibility of AOC.
It's still the
I believe
responsibility.
so. That's my recollection.
Is that the way it is in most state government? Let's say your office is
I haven't been issued a credit
I
card.
haven't had a credit card.
I haven't been. Now we do have, just like, and I believe in addition to those 3,
Pro
there
cards.
are also pro cards.
Correct.
And we do have pro cards that we
Correct.
utilize that, have certain requirements, but I myself do not have a pro card.
Correct.
I mean, I can tell you in private sector, it's the individual who's responsible, and they don't get reimbursed unless they have the documentation.
I think there's 2 ways that it can be accomplished. I think the way it's done at AOC, based on what we're recalling, is that the card is the responsibility of the agency. It is an agency card. The other way that you may have in mind is if an individual uses their own card and then says, "I need to be reimbursed from that." But I think it's appropriate if it's an agency card that it be issued in the name of the agency, and then that individual who's using that card is responsible for submitting the detail of how they use that card.
Well, I can tell you in the private sector, most of these cards are issued in the company's name with the individual's name on it. And the individual has to provide documentation to the company to get reimbursed.
And
I think that's consistent with.
I believe that's consistent with how it was at AOC as well. There were also, it's noted in the report, there were no cardholder agreements. Typically, when you have a situation as you just described, you'll have an agreement as to the cardholder's responsibilities, and the agency will also provide you with some parameters upon which you can use that card, and that wasn't the case in this situation.
Thank you, Mr. Chairman.
Thank you, Chairman. Talking about the credit cards leads me to a different area, and that is a lot of the things in the audit are sloppiness, but I think that the Court of Justice, the Chief Justice, the Director are going to fix immediately. There's no doubt in my mind. You've identified some expenditures of the Chief Justice and the Director of AOC. There's no doubt in my mind that there was nothing dishonorable there, dishonest, maybe not tracking appropriately or what you would have them do. But that's not any kind of question in my mind of honesty or anything like that. Although some of the other things in your audit do bring up the question of honesty, and that leads us into the surplus sales. Surplus sales is a major concern of mine, and I know that the executive director over auditing or finance, I don't remember his title, has been terminated in response to some of that stuff. But I also understand that there were a number of people equal to him or higher up than him that participated in purchasing some public property. One, is that true, that the director or executive director or others participated in purchasing property on an employee-only sale? And then number 2, has there ever been any discussion of a return of that property or disgorgement of profits made from sale of public property that they shouldn't have had? Any kind of conversation about that?
On the number 2, I'm not aware. On the number 1, I'll let Chris go a little bit more in detail. But there were other people. The person, obviously, in our report we mentioned, the private sales, both with furniture and vehicles. But
It seems to me that on that first question,
Yeah.
that I don't know if there's a policy or not, but it ought to be pretty common sense that you can't set the price, set the time, not tell everybody there's a sale, and then purchase it, especially when you've disregarded, voluntarily, knowingly disregarded the roadblock that was put up by your own internal control of your general counsel. That doesn't sound to me to be a sloppiness. That's a question of honesty.
And you can correct me.
So
Go ahead.
there was no policy in place for the aspects that you're talking about, separating that out and saying if you cannot set the sales price, coordinate the sales, and participate. There's actually a very good executive branch ethics opinion, which does not apply to the judicial branch, obviously, on this same question at the Finance Administration Cabinet going on, and the Executive Branch Ethics Commission said, you need to set up those barriers that you're talking about. So here you had a memo in 2010 from AOC's internal counsel saying we should do this the way the executive branch does it and have publicly advertised sales. Makes a lot of sense. There was no policy that we identified that agreed with that and set that as a policy. And so, yes, you had an issue there with an individual involved in activity on both sides that should not have occurred. That's both an issue for that former officer and for the organization as a whole, because it identifies a lack of policy, a lack of oversight, and that's where some of the overarching comments that the auditors talked about go into about your tone at the top. These examples that have been brought up about various things. Some of them are minor, some of them will be paid back and taken care of, but there's an overall atmosphere that needs to be addressed according to our report.
Did the termination of Mr. Brown not address it in your mind fully?
Not in my mind, because as I said, you have to have a control structure in place so that no matter who your employees or officers are, that you're able to identify those problems before 6 or 7 years go by.
And the surplus property specifically, I think in April of 2017, they started putting some additional policies, and I think they're going through the finance cabinet now.
Yes.
To sell their surplus property. So,
And that is an issue that is being addressed on the surplus property sales.
yes.
Thank you. Representative Reed.
Thank you, Mr. Chairman. If I may ask a series, couple questions and responses.
You have the floor.
Thank you. Mr. Harmon, we discussed it earlier, and I'm trying to wrap my mind around the obvious statement, but so this is the first audit of this nature since 1976, is that
This is
correct?
the
So
first external exam.
so
of
around
AOC.
42 years of this nature, is that correct? Okay.
Correct, correct.
So Judge Minton basically took over in 2008, is that correct? So is it fair to say that this is an accumulation of policies in the AOC, not since 2008, but since 1976?
Well, I would say without external oversight or strong controls internally, as we indicated earlier, it's easy for people to get off track.
So this is an accumulation of rules and procedures over the years of that magnitude. So I think it's a testament that Judge Minton, brings this to the table and asks you all, but it's also fair to say that this is the first time in 42 years that the state auditor's office has done the same to the AOC. Is that correct?
Yes, I mean, this is the first time they've ever had one, and this is the first time that the auditor's office has done an external exam of AOC. Yes.
Okay, so this is not necessarily a reflection over a certain administration, the AOC. This is an overview of policies up until this point in time
Well,
that we've first seen.
We believe it's obviously historic because it's never been done. The time frame we looked at was primarily at that 2-year span, although we did go back in certain instances to look a little bit further. We didn't go all the way back to the beginning of it, but certainly some of those policies probably evolved by not having proper controls in place.
Another question I have is, in that realm of thinking of checks and balances of that nature, you've done other audits through other agencies over this type of process and procedure. Is that correct?
Yes.
In your mindset, real fast, where does the AOC stand in that reflection? Worse, better, the same?
It would be difficult to assign that particular type of rating. Obviously, since they've never had one and we had 20 findings, it is very concerning. We've had some county governments, that would obviously be deemed much worse. But at the same time, we had some concerns, obviously, when we did the University of Louisville Foundation the governance examination of those, we had, concerns there. I don't know that you can necessarily put a rating on it. It was just something that was very much needed, and going forward, needs at a minimum a financial statement audit, going forward.
Well, Auditor, I thank you all for what you've done in this report, and I also want to give accolades to Judge Minton for voluntarily bringing this to the table as well. Thank you. Thank you, Mr. Chairman.
Thank you. I'm going to ask Chief Justice Minton to come to the table in just a moment, but I want to read off some external controls that have come to my mind and ask you to comment on any of these that you want to, and I'll ask the same of the Chief Justice. And I don't necessarily support all these. These are just the ones that come to my mind. By way of example, the open meetings rules that you suggest, it seems to me, this is just one man's opinion, that would be improper. Maybe it's because I've been in that room and the Supreme Court's different. I liken it to the governor and his cabinet. That's not open. And so I'm a little hesitant on that, but I'll list that as well. And if any of these that you'd like to comment on, an annual finance audit of AOC and all Court of Justice agencies that receive taxpayer money, the Judicial Conduct Commission, and so forth and so on. Open records laws, perhaps we need to amend that. I know the Court of Justice has enacted an open records law, but it has a major roadblock in that it says all emails are excluded. If they don't change that, perhaps we should. Contracts should be approved by the Contract Review Committee. Remove facilities perhaps from the AOC and put that in the executive branch where they build courthouses and oversee many facilities. They have an expertise in that. I know there are a number of these findings are misappropriations of or under appropriations or over appropriations of facilities, related facilities. Open meetings, which you've mentioned, and the legislative or the judicial branch ethics committee, which to me they already have with the Judicial Conduct Commission, and the canons. But you want to comment on any of those?
Sure. Well, on the last one first, on that particular one, that applies to the judges. I don't think it applies to AOC staff, which is really part of what we were talking about. From the standpoint of the open meetings, obviously we made that recommendation, and we stand by that recommendation when you're dealing with administrative matters. Now, the difference is between your comment regarding being the governor's cabinet, but the people that work for the governor and his cabinet are hired and fired at his will. The judicial, other members of the judicial body are elected by the people. So that would be a difference in that particular opinion. Some of the other items, I'm just trying to, big list I'm trying to go through, but really the open meetings was concerned from a standpoint, addressing the financial statement audit of the, maybe the subcomponents of the other items. We'd have to take a look at that a little bit more thoroughly, but I think any time that there's additional light shined on any organization, we believe that's a positive. We believe that's our role. During our original press conference, I was asked, whether or not I had lost faith or if people should lose faith in our judiciary system, and I said, really no. I mean, from a standpoint, these are important things that we believe need to be corrected. I kind of compared it to being a parent. You sit down with your kids, you've got some concerns them, you tell them, the concerns, you are very hopeful and prayerful that they will take your recommendations to heart. But I think our founders were wise in the creation of the documents that govern us. And so our goal in the auditor's office is to help them be better and continually better and more transparent.
Can I add regarding the open meetings issue? The governor's cabinet, I don't know, I've not been in the meetings, but they serve as advisors to him rather than as a decision-making body. And so any city council, the legislature, when they are making decisions as a body, that is an open meeting in all other aspects of government. So I view it a little differently than the governor's cabinet in that regard. I don't know if they hold votes there.
When that's challenged, you think you can get to 4 justices saying it should be open?
I would be happy to attempt to try.
Auditor, anything else in conclusion?
Yeah, only in conclusion, I want to thank the great work of staff. The auditor usually comes and I don't want to say takes credit, but the auditor is basically the person that comes forward and puts these issues forth. But really, I could not do near the work that we do, or really any of the work, without the great staff that we have that goes in and does the great job, each and every one of them from top to bottom. So we're just blessed to have such a great staff. I always hire people that are smarter and better than I am. So
Thank you, Auditor.
thank you.
Mr. Chief Justice, the floor is yours.